Thank you for attending this webinar, Contracts and Risk Management for Small Business Owners and Entrepreneurs. I am your moderator, Jenny Alton from the New York Small Business Development Center Central Office. Today's presenter is Jessica Magaldi, Ivan Fox Scholar and Professor of Business Law at the Lubin School of Business at Pace University. This webinar is brought to you by the Pace University Small Business Development Center and the New York Small Business Development Center. The PACE SBDC is part of that New York Small Business Development Center network of 22 campus-based centers and outreach offices, which are located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, this session is being recorded. We will share it with attendees a few hours after the presentation. Attendees are muted and will not be on camera. If you have questions during the presentation, please don't hesitate to type them in the questions box as they come up. We will have a Q&A session at the end of Jessica's presentation today. If you submit a question, we will not mention your last name or business name. For very specific questions that may take more time and detail to answer, or if we run out of time to answer all questions, someone will follow up with you after the webinar. Joining us to lead things off is Andrew Flam, Director of the PACE SBDC. Andrew, I will turn things over to you.
Great. Thanks so much, Jenny, and good afternoon, everyone. Thank you all for joining us this afternoon. Looking forward to inviting our colleague here at Pace University, Jessica Magaldi, in just a moment to lead a session on contracts and risk management. But very briefly, just wanted to review and let you know a bit more about who we are and what we do, in case you are not working with our center as of yet, or one of our colleagues throughout the state. As Jenny had mentioned, the Pace University Small Business Development Center, or SBDC, is one of 22 centers located throughout New York State, and our focus is on providing one-on-one business advisory services to both existing small business owners as well as aspiring entrepreneurs. And all of the services are offered to you at no cost. So if you are not working with an SBDC advisor as of yet, what I'll do in just a moment is put a link in the chat with our contact info. And we would certainly encourage you to contact us, and we'd be more than happy to work with you. Our focus really is on a wide range of issue areas that, as I said, both business owners as well as aspiring entrepreneurs work on. You know, issues such as access to finance, working through marketing and sales strategies, opportunities to be able to help you secure and deliver on contracts through the federal, state, and city governments, thinking about operational challenges you might be working through, and clearly over these last couple of years, how to be able to access the wide range of pandemic recovery programs that are in place, including one most recently launched that we from New York State as well as from New York City, that we want to make sure that you're aware of and sort of see how we might be able to help you access those programs if it's relevant for your business. So I will put a bit more information in the chat about some of our range of programming, but as I said, really encourage you to connect with an SBDC office to be able to work with a business advisor, help you through these different challenges, and again, all those services are offered to you at no cost. Our other big area of service is really focusing on training programs, where we really look to engage subject matter experts such as my colleague, Professor Magaldi, and looking at contract risk management today. So this is an example of the kinds of programming both our center as well as our sister centers throughout the state offer on a daily basis. So in addition to today's session, and one additional one I'd love to plug is we're very fortunate to have Professor Magaldi coming back again next week to be able to review a session that's going to be going over our non-disclosure agreement. So if that's a topic of interest to you as well, I'll put a link to that specific session coming up. I'll add that to the chat, as well as a link to all upcoming programming, so you can kind of pick and choose those that are of interest to you. Next week's session will be hosted here at Pace University, so you're welcome to join virtually, but we'll also have an in-person option if you are in the neighborhood and want to come by in person as well. We'd love to see you. So that reviews kind of our in-person and training programming. Again, the COVID recovery programming, we'll put a link in the chat for that as well. Really look forward to having you be part of the SBDC family and be able to work with you as we go forward. So today's session again on contracts and risk management, whether you're looking at how to be able to identify, opportunities that may be, being presented to you as a business, how to be able to build and grow and be able to take advantage of them, and obviously making sure that you're considering all the kind of the important legal ramifications that are in place in terms of, what that's going to entail. So important. I think being able to dig deep into those issues. We have a fantastic speaker who really is so well, schooled in these areas. I think you'll get a lot out of it. So without further ado, I'd love to introduce my colleague here at Pace University, Professor Jessica Magaldi. Jessica, turn the floor over to you.
All right, thank you. All right, so I'm going to run my own slides, and I've got my notes, so bear with me for a second. I am going to share my screen. And how's that look? I'm going to assume good, unless Andrew tells me.
That looks good.
All right, perfect. All right, well, thanks everybody. It is really nice to be here. One of the things that I really enjoy doing, for this group and for others, is being able to demystify things that, that cause people a bit of anxiety. Legal documents and contracts, often fall into that category. But there are, a number of principles that if you understand them, you can find your way, where you need to be, what help you need to get from experts, and what you can handle yourself. So a little bit about me. I spent 25 years in the legal technology industry, representing lots of small business owners, primarily in that jump that they're making from kind of when they had like their brother-in-law or their real estate lawyer do their contracts to, when they've grown their business big enough that they need some, help that's really targeted toward the work that they're doing. Prior to that expertise, I spent a number of years at a top Wall Street law firm, doing this for multi-billion-dollar contracts and for Fortune 500 companies. I also run my own business in that I have a legal and a consulting practice. So I'm kind of on all sides of this thing. So what we're gonna the objectives I've got for us today are, we want to understand the context of our contracting situation. We want to identify the key legal issues. Not that you're necessarily going to solve them yourself, but so that you'll know when to, when to seek out a lawyer, when to have legal assistance, and then, some appreciation of the significant key legal terms, so that you can be familiar with, what it is that your lawyers are talking about, and you can understand in particular the business issues related to those legal issues. So, I want you at the end of this, to feel that you're comfortable, that you're conversant with the general context of the contracting situation, with the language that, lawyers use. And then, I've got a section towards the end on kind of key issues that come up no matter what your industry is. They're the same kinds of things. If you asked me to look at a contract, outside of my specific area of expertise, there are 3 or 4 things that I or any lawyer would look for, and could advise, could advise are the most important things, related to any relationship that you're building. So, the most important takeaway is, for you to understand when you should call your lawyers, right? I know you're not a lawyer. I know you don't want to be a lawyer. Most entrepreneurs, the skill set, the interest is actually in things that potentially directly oppose lawyers. Lawyers want to slow you down. Entrepreneurs want to move themselves forward quickly. So what I'd like you to think about is kind of where those things meet, and we'll talk a little more about that. So first, just thinking about like kind of a general from a really broad perspective, what's a contract, right? So a contract's a private arrangement between two or potentially more parties, and it defines the legal rights and responsibilities of the parties in the relationship. And this is what I spent. I'm not a litigation attorney. I am a person who spends my time putting deals together. So figuring out what both parties want, so that they can each be happy with the arrangement that they are entering into. So this is a powerful notion. This idea that a contract is a private private interaction. So you don't need anything special. You don't need court's permission. You don't need to do anything particular. You can you make agreements, and then you bind yourself to those agreements by indicating that you want to be bound either by writing or a handshake, or we'll talk about some of that. And then you've got the full force of the law behind you. So if something does go wrong, then you can use the court system to enforce the rights that you have agreed are your rights, and enforce the responsibilities that each party has. And so of course, in a perfect world, you don't have to use the legal system to do that, right? To enforce those rights. But the idea that it's there, we hope, it gives an incentive for people to behave the way that they agreed they would behave. So this idea that, like, I can sue you, the real key is, or I can be sued, like, hey, maybe I should just do the things that I said that I was going to do, lest I find myself, being sued, right? To force consequences on me for not doing that. Any good contract, it's going to have, what I'm calling the Spider-Man role. The rights and responsibilities of each party should be, I don't want to say even, because there's all sorts of reasons why a contract might look like a good deal for you and not look like a good deal for me. And we can't see what's in the minds of people who are, embarking on, a relationship, whether it be a long-term relationship or a transactional relationship with one party. But the idea is that every right of one party is a responsibility of the other party. And so if I'm buying goods from you, if I am the buyer, then my responsibility is likely to pay for those goods. And my right is to then receive the goods that we agreed in the amount and at the quality and in the condition that we agreed. And your, sort of conversely, your responsibility is to provide those goods on those same terms, and your right is to be paid on the terms that we've agreed. So, my right is your responsibility, and your right is my responsibility, and each contractual arrangement is going to have a combination of rights and responsibilities for each of the parties. The more rights you want, you often have to take on more responsibilities. So to be trite, everything has a price. So I've got an example from a client of mine, which is I say a Fortune 500 company. I guess if you want to track them down, they're a Fortune 213 company, and they asked me to come in and to scope the work that they were doing so that they could bid it out for, to a number of parties who were going to, provide those services back to them. And my clients kept saying, like, can we get this? Can we get that? Can we add that into the scope? Can we add this into the scope? And my answer is always the same. Like, you can add whatever you want into the scope, but what may come along with that is, it may take longer for the other party to provide those services to you. It may cost more for those services to be provided for you, or you might have to lose, some other one of those services. So, there's this, a good contract has a balance among, a balance that makes sense for the parties who are party to the transaction, right? So it has some kind of a balance that makes sense within that context. So The key thing that you get when you get a contract is you get what we call the benefit of the bargain. So a contract gives you forward-looking damages. So if I agree that I'm going to provide you with a component that you're going to use for some larger thing that you're going to create, a piece of technology for, a more complex bit of technology that you offer to the world, or something like, brakes for bicycles that you manufacture. If I don't provide those things to you on time, there are going to be consequences to you. So you miss getting your bicycles in retail stores by Black Friday, by the fourth quarter of the year, which is the big the big time for consumer purchases, or you have to source your parts from somewhere else, and the price of those parts is triple because we made an arrangement for me to provide that piece of technology to you, a year ago, but now on the eve of your, the eve of the day that it was supposed to be provided, you have to scramble around and find someone else. So, what a contract relationship does is, in the event that one party fails to live up to their responsibilities, we look into the future and we see what we can do that will make you whole, that will give you the benefit of the bargain. So if you were supposed to pay me $10,000 for that component, and I'm not prepared to give it to you on the time that I said that I was going to give it to you, or the quality is lacking, or whatever the issue is, and you have to pay now 5 times that price to get it somewhere else so that you can meet your responsibilities to your, to other people who are depending on you, then I am responsible to pay you that 4 extra times amount of money that you paid. That's forward-looking damages. We don't return to what the law calls a status quo ante. We don't say, well, you know what, I'm not gonna be able to, sorry, I'm not gonna be able to provide the parts that I promised, and then you don't get, then you don't have to say like, well, okay, well, I guess I won't pay you for them, right? That would unravel us back to the point at which we started this whole thing. But the law doesn't want to put you where you started, because you didn't start negotiating an arrangement and then come up with the parameters of your relationship. We want to be where we were supposed to be if everything worked out as it was supposed to, which is what a contract is doing for us. We're saying right now that this is what our future is going to look like. Our future is going to look like, I'm buying this from you on that day for that amount of money, or you're providing that service to me, for this amount of money. So what we're looking for with a contract is to put you in the position you would have been in had the contract been performed as agreed. We want to compensate you for what should have happened, and we want to create the situation so that you are, so that we are all in the position where everyone gets what they were supposed to get if everything had gone right. So that's what we call the benefit of the bargain in that circumstance. So we come from the perspective that no one really wants to sue. It is tremendously costly. It is time spent away from your business. It's emotional and mental energy that you've got to spend in preparing for a trial. And truly no one understands this better than someone like me, better than a deal lawyer, someone who wants to put people together. So what we're trying to create is a good contract that avoids a lawsuit by really clearly setting forth expectations and what's going to happen in those situations. And so, what are we doing there? A contract manifests an intent to be bound. There's a couple of different ways that we think about it. We call it the meeting of the minds, right? So you're providing this component to me at this price, and I believe that I am buying that component for you at that price. So we've got a contract when we have this mutual understanding. We base that mutual understanding on an objective standard, what a reasonable person would conclude. So we think about, the words on the page and how they ought to be interpreted. And we might be thinking about those from like literally what the words say and what any reasonable person would say, or if there's any particulars to our industry, that this is what these terms of art might mean. And what this means also is that, there are no formalities required for a contract. And what I mean is, there are certain situations where you need to have a contract be in writing, particularly purchase and sale of real estate, or sale of goods over a certain amount, or for some service contracts that can't be completed in less than a year. But except for the specific things where things absolutely have to be in writing and the law requires that, there are no other formalities required. You don't actually have to write anything. You don't have to necessarily sign it. You have to manifest your intent to be bound in some reasonable way that you can do it. And so this is a picture. It's a little blurry, but this is a picture of a contract written on a bar napkin, where a parent of a soccer player engaged an agent by to work on behalf of the child. And it's on a bar napkin. It's got a couple signatures on it. What does it have there? It's got the words that say what the parties are going to do, which is the manifestation of the parties' intent to be in business together, and it's got the two signatures on it. So why is this relevant for you, right? So if a bar napkin can count as a contract, then in many circumstances an email also counts, a text counts, a phone call counts. So we don't often, so we may see this in terms of when we are starting contract, but a key thing to be thinking about around this is modifying contract terms. And so a lot of times what we do is we write into our contract that we need some formalities in order for them to be amended. So we're trying to sort of save ourselves from ourselves. So many contracts will have clauses, usually in the sort of the last section, that speaks to, that's kind of a hodgepodge of all the extra little legal things that we might have, that say that contract modifications or waivers of performance or important communication about accepting deliverables or about changing the timeline for something ought to be in writing and only can be signed by certain parties. You might see sometimes people put in their email signatures, nothing in this email is intended to be an offer or an acceptance. We need more than that, but you might, the sort of practical way this comes up is I'm supposed to deliver you something by the Monday before Black Friday, and I text you and say, I'm not going to be able to make it, and you say something like, okay, and your okay might be, okay, I hear you, right? But I might be able to take your, there might be some misunderstanding, and I take your okay as, okay, that's fine. Or it might be, okay, I'm not pleased with this, but what are we going to do from here? And, another way to think about it is that, okay, yeah, I'm off the hook. So, so to that point, lots of people try to, one of the points at which entrepreneurs and their legal teams tend to not see eye to eye is on working without documentation, right? Lawyers like to button everything down, and business people often want to move forward. That's why you're successful, because you're moving more quickly, and you are taking advantage of opportunities when they come to you. So but it's much more difficult to prove what your terms are if you have a handshake or have a cocktail napkin kind of arrangement. It is unless you have spelled things out. So your lawyer's always going to ask you to take that time to be very detailed, and there's going to be a push and a pull there as you figure out what the right way to work for you and what the right way to work with your lawyer is. But the key to be thinking about this, in a perfect world, if you write it down, you've got a sense of where of what you've truly agreed. There's less room for for misunderstanding, because your memory is not going to be what it could be, and credibility is going to be hard to determine. So if we do end up in a dispute over what our arrangement was, we are notoriously bad as a species of determining who's credible or not. The kinds of things that we use as a proxy for, deciding if someone's not telling the truth or not, or were they sweating, were they kind of looking shifty or whatever. There's all sorts of reasons why people could look as if they're not telling the truth, because, where, someone's nervous to be on the witness stand, or, nervous to be speaking to a CEO about what they remember. Serial killers, sociopaths are notorious for being excellent liars, but the sort of, regular person living their life, maybe it isn't quite as practiced at that. And then memories matter, right? Like, you may have a very clear understanding of, you may have what you believe is a very clear understanding of what you've agreed, but it may actually differ from what reality is. I put this little picture up about this. This is a book that my children read when I was preparing this presentation. I had heard from the parent, a parent who's a friend of mine, who lent us this book, and she's very particular about, she buys sets of books, and she likes to keep all of them. If her kids like one book, she buys all 5 of them, if however many there are. And so she lent us this book. She wrote her name in it, and and she said, like, just be sure to give it back to us. And I said, oh, absolutely. And a few months later, she said, where I was looking for that book, did you return it to us? And I checked with my kids, and I, checked my own memory, and I'm like, I'm absolutely sure that we returned that to you. And here's the, here's when it was and how it went and all of that. And literally, like 2 days later, I was sitting at my desk putting this presentation together, and I looked over at a little basket that we have to catch all the sort of, random things that wander about the house sometimes. And there was the book sitting in the basket. I was very sincere when I thought that I had returned it to her, and it wasn't even close. So here are some of the things that, if you work without a signed contract, you may, find yourself having a misunderstanding about, right? Assuming good faith from everyone, but you might have a misunderstanding about, there's a lack of clarity about the parties' obligations. When are deliverables due? Who's going to sign off, or when, or how, or what the right terms are to sign off? When do we know that it's been completed? What's the timing of payment? In terms of liability, contracts, one of the key things that contracts can do is limit one's liability, so that they take note of the particulars of the relationship, and then find the right place for each party to take on the right amount of risk in the relationship. So without a signed contract, there's no cap on liability exposure. You may be responsible for consequential damages, which are damages that are more attenuated from the breach, kind of if the breach is one domino, then like many dominoes, one hits the other, if I can use that metaphor. And ownership might be unclear, right? So an independent contractor owns their creation. So if someone has engaged in a relationship where they think they are going to own the deliverable, they wouldn't. And so that would be an issue. If you're the independent contractor, the law might protect you, but if there's a misunderstanding, if there's a lack of clarity between the parties, you can still fight between yourselves as to, who owns what. And the client may have rights that you didn't intend, right? If you are the party who's providing services. So lawyers are often asked, could we just do something quick? Could we just put something small together so we can get going and start, start working? And these types of things are called, often called letter of intent or letter agreements, memo of understanding or an MOU. They're good for, they certainly have their place, and they're really good because they prioritize speed over certainty, right? So if you really need to get to, get into this relationship and move quickly, you can, with a shorter document, you'll have fewer things to negotiate, and you can, move forward. What you trade off is certainty over all the other things that you don't mention in that document. So if you are comfortable as a business owner, as an entrepreneur, with the increased exposure, and you think that that's an acceptable risk, then you are, then that is, certainly, your right to do that. Or if you truly believe that the exposure won't be too risky, you think this party and you've worked together before and you are comfortable, taking on the fact that that bad things could happen, because of course lawyers are, that's our job, is to figure out kind of what the bad things are and worry about all those worst case scenarios. So the decisions, really the business owners, as to how much risk you can, you're interested, willing, able to take on. And in fact, so the best way to think about this, and this goes for working with no contract, or working with a bare bones contract, or how to even negotiate terms as we go through, even if you were negotiating a full-on robust contract, is, well, what are your business priorities, right? And so, there may be really good reasons why you are willing to take on more risk than your legal team thinks you should take. Maybe the financial payoff is going to be, significant. Maybe this is an extension of, your work into a new vertical, a new industry. Maybe, you've got a famous or influential client, and if you can, work with that client, then, business will just flow right after that. Or you can work in a well-known or a highly visible location. If these are things that are important to you, there's absolutely a reason why you might say, I'm willing to forego, some of the concerns about risk that my lawyer's advising. The key thing is to find the right balance, the acceptable level of risk for you. And very often I get very frustrated when I hear legal teams who are slowing down the business side, who are difficult to work with, who are insistent that certain terms need to be included in every contract. Rather, the better way for a legal team to work with a business or a creative team is to, detail all those risks, and then let the business decide for themselves what the acceptable level of risk is. So there's definitely a, kind of a push and a pull, but I think the lawyers don't stay in their lane if they are insisting that it absolutely has to be, it has to be this way. I had a funny conversation with my mother, and she said, oh, my kids, they never listen to me, right? She's talking about her 3 adult children, of course. And I said, well, it's possible that we listen to you, but we make our own decisions. And she said, oh, you don't know what it's like. You don't know what this is like. She said, I have young children, and, they kind of do what I say, more or less, is where she was coming from. But what she didn't realize is that this is what I do in my business life all the time, right? I am constantly telling people what the risks are, and then recommending a course of action, and then having them decide, I appreciate that perspective, but I have these things to think about, right? So my feelings aren't hurt like my mom's were with her kids, right? Because, my belief and the belief, the way a healthy relationship with your legal team works is that it's up to the business to decide, what the level of risk they want to take is. So it's up to me to say, okay, and your lawyer and your relationship, it's up to me to say, okay, you've had your conversations with the client, you've talked to your partner that you're working with. Okay, how can I minimize the risks that and you need to go forward in this way because this makes sense to you? How can I do 2 things? Advise you about what might go wrong in that situation, and if you are committed to this role, minimize the risk of how of your preferred path, right? And of course, many times, I may convince you, your legal team may convince you that, like, if you take this path, the risk will be too great. But that's entirely on the business and the creative side. So what we're doing then is we're trying to put together a document that clearly defines our expectations, business, creative, legal, between the parties to the contract, and then we can move forward with that, sort of with that manifested intent of how our relationship is going to look. So that brings me to, okay, so what are some key terms, right? What are some legal terms that you can familiarize yourself with, so that when you are talking to your lawyers, you have more, you have more ability to understand and appreciate the, the things that they are worried about. And there's three key legal issues in contracts. As I said, no matter what your industry, no matter what kind of contract, no matter what your relationship. And the most important one is going to be liability, right? There's going to be limitations on who's liable for what. If you're working with a contractor, there's going to be some relationships where you want to make sure that you've aligned, whether you're the contractor or the prime, whether you're whichever side you are on, you want to make sure that those that the relationships align, so that if the prime contractor has responsibilities to the client, then the subcontractor has similar responsibilities to the prime contractor. Otherwise, that prime contractor, if there's a misalignment there, is potentially going to owe to the client what they're not getting from the sub. So, and then you want to think about, how does this line up with what your insurance is? Can you take on this risk if it's not covered by your insurance? Because that will also be an area of liability for you. So I'm going to go into each one of these categories more in depth, but I want to just highlight them all to you right now. And then there's what happens when there's a dispute, or a dispute so bad that the parties need to terminate. So there's going to be some limited time in which you can bring claims, right? Called the statute of limitations. Maybe we've heard about that, or we've even colloquially people use that term. What's our choice around mediation, arbitration, litigation? How does that affect what we're doing here? And then, what rights do we have? I might terminate, but then am I responsible to continue paying, or will I be able to continue to get services to wrap the relationship up? And then ownership, who owns the copyrights to things that a service provider creates? What rights, if you're the customer, do you have to make use of the intellectual property that you have paid to have developed? And certainly one of the ways around that is to tie to, no rights to the customer will vest unless they have actually paid the service provider for the work that they're doing. So we'll take these kind of one by one. So liability, I said there were, limitations of liability, and exculpation is a limitation down to zero, so a limitation of liability is, is just that, I'll be limited to 3 times the contract value. An exculpation is I will not be liable for this type of damage at all. Subcontractor flow-throughs, as I said, and alignment with insurance. So I pulled some contract provisions here, just kind of see, what a typical contract might say. And we could jump into limitations of liability here. If you look at section 8.1.2, we're saying, to the extent that damages are covered by insurance, we waive any rights against each other for the damages, except if insurance covers them. So this is a really clear and easy. This is a contract between architect designers and the owners of property that they're doing work for. But it applies, it applies in lots of other in lots of other areas, and this is a common way to limit liability. So you're saying, so if something goes wrong and I'm responsible for it, I will, I will compensate you with money for that, only to the extent that my insurance covers that. So of course, if you're on the other side of that transaction, you want to inspect the insurance and see what the carve outs that the insurance are, what the limitations are, how the insurance actually works. But for the service provider in this sense, it's sort of a beautiful way. It's a very clean way to limit liability, because you know that you will not be out of pocket any money in this circumstance. Another way to limit liability would be to it's on the bottom here, limit it to a dollar figure, potentially the contract value, or some formula. And you might want to think about the difference between the amount paid by the contract or payable by the contract. So even if in that first bullet on the bottom of the slide there, it says dollar figure, often contract value. Yes, but if the contract value is $1 million, but you've only paid me $20,000, then I want to limit my liability to $20,000. If I'm on the other side of that, right, then I might argue that limiting liability to the value of the contract is more appropriate, and it doesn't matter how much I may have paid along the way. It's not about like giving me a refund. It's about taking on risk that's commensurate with the value of a contract. And these are the kind of conversations I have with my clients quite a bit, because if you have the opportunity to take on a significant contract, a contract of significant value, you may well be willing to take on more liability. What I often find, or what my clients often find is the other way. A good client will say like, well, wait a minute, I'm not going to have unlimited liability. This contract's only worth $20,000. If something goes wrong, and I'm on the hook for an unlimited amount of money, it's not even worth it for me to embark on this small relationship. Whether a contract says it or not, you can never limit your liability for intentional bad acts or gross negligence, a significant departure from what anyone would be doing, a reasonable person would be doing. So I am I'm a technology service provider, and I'm redoing the email system for your company, and I do something that is my fault, but it's the kind of thing that it happens, right? So we would call it negligence. It's a departure from what we would expect, what we would hope a reasonable person would do, but and it would be the kind of thing where I would be liable for that. I will limit it to our formula or our contract value or the amount payable by insurance, but I'll be responsible for my actions. If, however, one of my employees, intentionally releases a virus, to wreak havoc on your systems, that's an intentional bad act. I can't limit my liability for an intentional bad act. It would be, it's against public policy. It would encourage people to just, act however they want then. So I would not be able to limit my liability for that. Even if your contract doesn't specifically say these things, they are, the law will not let you off the hook for those kinds of things. And so another way to think about, another way to think about these things, I'm sort of going up the slide now, at the top of the slide is, you want to think about whether your contract, whether your limitation of liability is going to be mutual or not. Sometimes a service provider might say, service provider is only liable up to this amount and is silent on what the customer or the client's liability is, which would mean the customer or client's liability is zero. Is unlimited. Now, On the other side of that, it may be that the customer or, client has, little opportunity to, to cause damages. So you want to think about whether you want to fight for that or not. And you want to think about who's benefiting from a mutual limitation of liability. But overall, I think most parties are more comfortable if you limit your liability, then I'm going to limit my liability, and and can find their way there when they need to. So another bit of liability we have here is around consequential damages, right? So consequential damages are the damages that come not from the immediate thing, but from the thing that comes later. So you are an architect and I am an owner, and you are redoing my backyard, and I don't say anything to you about this, but my plan is that my my daughter's going to get married in my backyard. And so when you are late in finishing the work, I now have to find myself a venue for 250 people on a weekend's notice, and I pay astronomically. That is the kind of thing that would be a consequential damage. It's not the if I'm late, if I'm the architect or the the builder, and I'm late in providing the work to you, and you find yourself having to be in a hotel for a week, that's a responsibility that I could immediately expect. Like, well, I'm going to keep this family out of their home for a week. I'm going to be responsible for that. That's a direct damage. A consequential damage is something that is not anticipated under the circumstances. Well, I didn't, have any way to know that I was going to cost myself or the other party hundreds of thousands of dollars in damages because they needed to find a new venue. So what you're going to want to do is you're going to want to waive consequential damages so that you're only responsible for that first breach, that immediate thing that came through. I just caught sight of the time, and I'm going to maybe speed up a little bit here. So when thinking about subcontractors, I already previewed a little bit of this for you. You want to beware of a liability cap to make sure that that if you have a cap with a subcontractor, if you're the prime, then you also pass that cap along to the client. So you want to make sure that you've aligned these things. And one of the things you're going to want to do is seek indemnities. An indemnity is indemnity is a provision where the party will step into your shoes and defend that claim and then be liable for it. So if I am sued by my client and that is because of something that a subcontractor or another party did, I can sort of pass that liability on to that party, and they'll defend the claim and they'll be responsible for the damages. Here's the little graphical depiction of that, right? If the client sues you, then you're responsible for the client, and the subcontractor is responsible to you. So you want to make sure that that passes through in that way. So disputes and termination, there is a time to bring claims. There is a variety of mechanisms by which you might pursue your remedy, and there are termination rights and responsibilities. Generally speaking, a statute of limitation is meant to give you sort of peace of mind so that you're not liable for anything related to the contract after that period of time. In most jurisdictions, 6 years is a default rule for contracts. So when you know that 6 years have passed from the time that the contract was completed, there can't be any more. Lawsuits on that contract. This is important if you are being purchased by another entity, right? They're going to look at your contracts and they're going to try and figure out what liability you might have that's outstanding in those contracts. And so a statute of limitations can give someone who's doing due diligence on a target that they may want to acquire, can give them the peace of mind that there will be no outstanding issues that come up related to this relationship. So 6 years is a default rule, but a contract provision, you can change that rule to whatever you are comfortable. You have choices in how you're going to handle your disputes. Mediation is a voluntary process where the parties try to work things out. Litigation, obviously going to court, and arbitration is a process that works like a court process in that there is a person who makes a decision, right? Mediation, the third party is trying to bring the people together, and in arbitration, it is the third party who is making a decision. The kinds of people who, the kinds of situations where you might arbitrate is a few different reasons. You might arbitrate if you are if you think you will not be served by a jury might be too sympathetic to the other party. This is what cell phone companies do and cable companies do, right? They don't want to have a jury in there because we've all had problems with our cell phone companies and we've all had problems with our cable companies. I mean, cable companies might be the most hated entities, on the planet. And so, they're afraid that people's emotions are going to get better and the better of them, and they're going to side with the little guy. But another reason, if you want to put it this way, like a reason more grounded in in fairness would be that it's too difficult to educate someone in your industry of what the ins and outs are of your business. And so rather than try and put all that complex information in front of a jury, you might just have, or a judge, you might just have an arbitrator do it. So you see this a lot in insurance. A lot of times when insurance companies go to arbitration, they just use a third insurance company that wasn't involved in the dispute. Car insurance, car accident, I've got my insurance company, you've got your insurance company, they make some decision as to, who's right or wrong, whose fault it is, who should, who's responsible for the deductible, that kind of thing. When the two insurance companies dispute, they just go to a third insurance company. They know how it works. They can quickly, and they go through them, one by one, really, really quickly. So that's a good reason to use arbitration if you've got some specialized information that you rather not spend the time to educate folks on. So ownership, I save it for last, but it's often, the most important thing. Often you're starting a business, or you're an entrepreneur. You've got what you think is a secret sauce, and you want to figure out, how you can provide it. So, as I said, ownership rights. What rights a service provider offers to a customer, and they should be related to full payment. So in this example, we want to be clear about who is the author of the work that they create. And by law, the author, and we use that to mean, the law uses that not just to mean an author of a written document, but the law uses it to be the owner of the creator of a copyrighted work. So the author starts with the ownership, and the author is the person who, the person or the entity who maintains ownership in a relationship, unless they turn that ownership over to someone else. The better way to do it, and they have to do that in writing by contract, the better way to do that is to give a non-exclusive license to use that work, right? So I said this is an architect's agreement, so you can see, the kind of work that an architect might produce. But I said that I represented a lot of, the technology companies. So if you're asking a technology company to, build a product for you, they're going to use code from their code library. They're going to use the types of things that they have done before. They're going to implement their algorithms in a similar way that they may have done before. They're going to create a product that looks different from other products that that they can provide to the customer. But the work that they're doing is going to draw on lots of their own other work. If they have to give ownership of that finished product to the customer, they have two types of problems in that situation. The first is they might not own all the other things because they have not used this relationship in the past. So if you want to own something, then I have to start from a blank sheet of paper, right? No access to my, metaphorical paper, no access to my code library, no access to the strategies and things that the intellectual property that I've used before. I have to start from scratch. the sort of other side of that is, and then if I give you ownership of that thing, then I can't use that for anyone else into the future. So the most important, thing that a service provider of technology or architectural services, anything where there's an intellectual property component, is to maintain that ownership and to give the customer an unfettered right to use, limited as ever you might see it, but you can go as far as a significant unfettered right to use that thing for its business, as broad as they need to, but they can't own it. And so if everyone that came before had was given only a right to use, then you can maintain ownership, and then you can keep repurposing that product, slicing and dicing the material that you have into a new product for another party. So the last thing I want to talk about is kind of where I started in the, in the beginning, some tips for dealing with your lawyers on these things, right? So, anyone that you've got to sort of interact with, the best thing you can do is give them lots of lead time, right? They're often juggling a lot of priorities, and they're often, dealing with clients for whom, everything is an emergency. To the extent that you can, get to them early, that's always a good idea. But the important thing that you can do, right, from yourself is to consider what your business priorities are, to educate your counsel, and to clearly communicate what you need, right? The clients that I have the best relationships for, I know what they're going to say. I know the level of risk that they're comfortable taking in a lot of circumstances. So I can say, here's what I think, given where I think what you think is important, right? And then there's always a circumstance where my client says to me, oh no, wait a minute, this is so important, I'll take on that level of risk. Or I've been pleasantly surprised the other way. No, I want to take less risk in this situation. It's just not worth it to me. But if I can get, sort of 80% of the way there, it helps our relationship. And the only way I get that way is because they talk to me about what they need, what they want, what they think is going to be important. And of course, you're going to want to listen, and consider their advice, but you're going to push back as necessary because the decision is yours, right? So you're going to say, like, I hear what you're saying. You think this is an unacceptable level of risk, but I'm willing to deal with that level of risk. So now tell me, counsel, how can I minimize it? If so, right? Or just, thank you, but no thank you, right? I'm willing to sign this agreement that the other side's put before me without the changes that you've proposed, because it's important to me for reasons X, Y, and Z. Thank you. So this is me. This is who I am. This is where you can find me. You can find me on LinkedIn, and I tweet once in a while. And that's my email address. But of course, you're gonna go through the SBDC, who've got tons of people on hand to help you with the very specific things that you may have. And so now, questions?
Yes, we do have a few questions. The first question is, how much flexibility does a vendor have when negotiating contracts with government, like the City of New York?
So that's not really a legal question. That is a business question, right? I see Andrew, nodding over there. Often it is not much. And so, understanding those parameters will help you, sort of appreciate where you need to be. But Andrew, do you want to say more about that, or?
Yeah, I think that it's clearly there's a legal component to it, but I think, it's a function of, if you're the small fish kind of, negotiating with a government entity like that, there's not a lot of wiggle room. And in particular, I guess to Jessica's point, this is a business term as well. So if you know that, let's say, there's going to be, lengthy schedules with respect to kind of getting paid for work that you've done, and I'm not calling out the city specifically, it could be any government entity, it could be a private entity for that matter. You need to make sure that you have enough cash flow on hand to be able to carry those expenses. So having a line of credit or having some sort of reserve in place is really important, and SBDC business advisors can help you with that. And the second thing is also, and I think, Jessica really kind of nailed this, is it worth doing in the first place? So if your margins are slim and you're not getting paid on time, how important is a contract like this to you as a business owner? So being able to understand that, being able to recognize that is really so crucial.
Yeah, early in my career, I represented a company that was creating products with Disney licenses. And, I was a young lawyer, so I was like, these terms are terrible. Like, we can't take these terms. And they were like, the senior lawyers with me were like, yeah, that's Disney. If you want to do business with Disney, those are the terms in which you need, that you need to meet. And so, my client, we figured out a way to work it out, to your point, the concerns that you might have with working with the city. But it's the same idea, if you want it, if it's important enough to you, and you think that there's enough upside in it, you'll figure out how to minimize the downside. Yeah.
We have another question. What are some key watch-outs that vendors should pay special attention to?
Well, I think I gave the key watch-outs that I think are the most important. Giving up ownership of your intellectual property without being paid appropriately, or giving it up without in a way that you can't use it again. Exposing yourself to too much liability. Yeah, beyond, like there are again, whatever the things that might be specific to your industry, are the kinds of things. But so those are the, I feel confident that I hit on the things that I think are the sort of most important things that travel across industry. But I would say that taking it out of the legal context, except for things like government, or Disney, like I would say, like if the negotiations take your cue from how the negotiations are going. If the negotiations are difficult and they seem to hang up on the tiniest of things, in my 25 years of experience, then the relationship will be difficult and will hang up on the tiniest of things. We're the same people, in the forming of the relationship as we are in the performing of the relationship. And so I would say, if you're looking for like, what should I be aware of? You should really have a sense of, am I comfortable that, with the way these, parties are working? If they feel a little shady in the legal terminology, are they trying to bury things in the small print, metaphorical or actual small print? Then are they the kind of person that the kind of entity that I want to do business with?
Excellent. I know that we are at time now. We have a few more questions, but we will make sure that those questions get answered after the webinar. So thank you so much for joining us today. And thank you so much, Jessica, for this very informative webinar. We've had lots of things coming in through the questions box. You will receive a follow-up email, attendees, a few hours after today's webinar with a link to the recording, and you will be able to review Jessica's slides in that recording. We kindly ask you to take a few minutes to give us feedback in the webinar survey that displays after the webinar and is linked in that follow-up email. If you have questions related to this webinar, you can reply to the follow-up email to contact the PACE SBDC. Andrew, did you have any last words for us today?
Just to thank Jessica, as always, for a terrific and very insightful presentation, and Jenny, for helping pull this together and making sure we went off without a hitch, and for all of you, I guess, for sticking through, and a lot of meat, a lot of really helpful information there. And just to kind of make sure and reiterate, there's legal components to your business decisions, but there are also business components, and there's often kind of they merge and blur, and I want to make sure that you're kind of recognizing the fact that there's a lot there, and that our center, as well as our colleagues throughout the state, are here to help you. So if you have not worked with and are not working with a business advisor as of yet, again, would encourage you to email us at sbdc@pace.edu so we can work with you. And again, all of our services are offered at no cost. And thanks very much.
Thank you, Jessica and Andrew. Have a lovely day, everyone. Bye-bye.
Thanks. Bye.